Well, good afternoon again, and welcome to the Texas Public Policy Foundation's Policy Orientation. My name is Robert Henneke. I'm the General Counsel here at the Foundation and also run the Foundation's litigation center called the Center for the American Future. I want to welcome you. Thank you for being here on this discussion about the Endangered Species Act on our panel entitled Birds to Bears, a look at efforts under the Endangered Species Act to delist recovered species. And to give you a quick overview of our program here today with the amazing panelists that we have, we're going to give you some snippets of 3 current cases that highlight this issue. I'll moderate some discussion, and then we'll leave time at the end for any questions that y'all may have about this. One of the things I want to point out just from the beginning, and for the record, that at TPPF, because we are a 501c3 research institute, we always pride ourselves in trying to have a balanced perspective during our discussions, and we will have here today. But I think it's important to note that we did extend an invitation to a number of environmental groups, Sierra Club, Wildlife Defenders, and the Travis Audubon Society to join us here today, and 9 of them accepted the invitation. But in the topic that we have today, the Endangered Species Act is a law from 1973. It's one of dozens of environmental laws that were passed in the 1970s. And it was intended to protect critically imperiled species from extinction as, quote, a consequence of economic growth and development untempered by adequate concern and conservation. The Endangered Species Act was signed into law by President Richard Nixon on December 28, 1973. And it's interesting that the United States Supreme Court has found that the plain intent of Congress in enacting the ESA was to halt and reverse the trend towards species extinction, whatever the cost. And it's not an exaggeration that I highlight those phrases, because whatever the cost has been interpreted to be at a consequence to humans, to the economy, and so on and so forth, that the U.S. Supreme Court has said is less important than the Endangered Species Act. You have 2 federal agencies that administer the Act, the U.S. Fish and Wildlife Service and the National Marine Fisheries Service. It's interesting that within the Act, the stated purpose of the Endangered Species Act is recovery of species. But in the nearly 40 years that the Endangered Species Act has been in place, while over 2,000 species have been listed under the Act, only approximately 50 species have ever been taken off of the Endangered Species Act, which begs the question as to whether the stated goals of the ESA are actually working, or if you don't, in fact, just have perpetual federal regulation once a species has been put on. And I think it's also important to note that violation of the Endangered Species Act by ordinary citizens carries with it both civil and criminal penalties that can lead up to incarceration. So in our discussion here on Birds to Bears, a look at efforts under the Endangered Species Act to delist recovered species, it's my privilege to introduce our panel here today. First of all, we have Mr. Mark Havens. Mark, here to my immediate right, currently serves as the Chief Clerk and Deputy Land Commissioner for the Texas Land Commissioner, George P. Bush, and the General Land Office, and is responsible for managing all aspects of the agency. Mark obtained both his undergraduate degree and a master's in public policy and administration from Baylor University prior to receiving his law degree from South Texas College of Law, and he began his legal career as an associate with Harbor Smith Harris and Merritt in Longview, Texas, before serving as the director of oil and gas legal section and is one of the preeminent experts in oil and gas law here within the state of Texas. Cristen Wohlgemuth, I'm pleased to have join us. Ms. Wohlgemuth is the Executive Vice President of Mountain States Legal Foundation. She graduated from Texas A&M University and also has a law degree from I think, St. Mary's Law School, excuse me. She served as, Ms. Wohlgemuth served as a budget planning and policy advisor to Governor Rick Perry, focusing on natural resources issues, has served as a chief of staff to the Chairman of Appropriations in the Texas House of Representatives, and prior to her service at the Mountain States Legal Foundation, served as the executive director for the Claremont Institute's Center for Constitutional Jurisprudence. Finally with us, I agree, is my friend and the senior attorney with our Center for the American Future Litigation Center here at the Foundation, Ted Hadzi-Antich. Ted is a senior attorney here at the Texas Public Policy Foundation. He served for 40 years as a lawyer in a variety of capacities in federal and state government, private practice, teaching law, corporate counseling, and prior to joining the foundation, was a litigator with the Pacific Legal Foundation. He is a member of the bar in 5 states, numerous federal courts, and also the United States Supreme Court. Would you help me in welcoming our panel today? So by way of quick introduction and background, the first case that we're going to discuss involves an effort that's being led by the Texas General Land Office to delist the golden cheek warbler from the Endangered Species Act. Mark's going to speak to the merits of that case, but here in just a second, we're going to show a video that kind of gives an introduction into the case and the subject.
It's not the South, it's not the West, it's Texas. There's an indomitable spirit here that can't be quenched. We have a unique history that sets us apart. I think most of us agree that the American dream is about being left alone and living a life that's independent of others. Even more important than the individual, it's about the family, it's about heritage. It's about what Texas is all about. Personal level, there's nothing more fundamental than the idea of the American dream and achieving that through economic security, which for many people is ownership of land. What would it mean for future generations if we allowed the federal government to intervene in property ownership?
Mark, tell us about the warbler. Tell us what we have going on.
And I'd like to first just say thank you to TPPF. I can't say enough about the good work and the mission that y'all do here. And as since Commissioner Bush took into office, we've had a great relationship with TPPF and really respect the work that they're doing. And to touch on the General Land Office just for a second, to kind of tie into this warbler litigation, for any of y'all that may not know and think, why is Chief Clerk of the General Land Office sitting here? What does that have to do with anything? It's the oldest state agency in Texas dating back to the days of the Republic. One of the interesting things is when Texas was entering the Union, we had a lot of land and were very little to no cash. We talked about entering the Union, worked on a few deals, and said to the feds, we'll give you all of our land, you take all of our debt. The federal government went out a lot to the land out in West Texas and the Permian Basin, that area, and looked at it and said, that'll never be worth anything. Why don't you keep your land and you keep your debt? So depending on where you fall, one of the first in a long line of horrible decisions by the feds, we came in and kept all our land. Today, over 13 million acres of that land has been set apart to the Permanent School Fund, which is what the GLO manages. So we manage over 13 million acres of land throughout the entirety of Texas. So we are the state, but in a situation like this, we're a private landowner. We're just a large landowner, so we get to deal with the feds in a lot of different areas, the warbler being one, the dune sagebrush lizard another, where they're striking at the very heart of the economic engine of the Permian Basin. So we have a lot of contact with feds in that. The warbler is it's an interesting situation. In the GLO, we have a fiduciary duty to maximize revenues. We do that through oil and gas drilling on our lands, as well as through investment in real estate. One such piece of investment was a 2,400-acre ranch in Bear and Kendall County. We bought that as an investment to later develop and sell. So what does that have to do with the warbler? Well, if you go back to 1982, the warbler first popped up on Fish and Wildlife radar as this is a potential candidate for listing. Fish and Wildlife said, you know what, at that time, we don't think there is enough data available to list it, kind of tying back into the original intent of the act, and said, let us take a look at it. We'll see if anything pops up. So we think, going back to do some more research and look at it, then in February of 1990, a petition is filed seeking an emergency listing. It's not just a listing for this. Things are so dire and such a horrible situation that we have to go through an emergency listing to prevent further problems with the bird. It's a little odd that we move from let us take a look at it and see what's out there to this thing is on the verge of extinction. We've got to move quickly. In May of 1990, there was a rule listed that said, yes, we have found sufficient reason. We're going to list this thing. One of the things when you talk about the original, kind of the intent of the Endangered Species Act is you look at the habitat surrounding. If you're going to protect the animal, the species, you're going to protect the habitat. So on December 1990, there was a final rule listing the warbler as endangered. And all throughout, they talked about all the damage and the potential threat of destruction, development to the habitat. So one of the mandates under the ESA is, okay, we'll find this as threatened, endangered, and we're going to designate critical habitat. This is going to be the area that's protected and allow the species to thrive. Interesting to note, in that final rule, the service did not designate any critical habitat. It was such an emergency. We're going to go through the emergency listing. We're going to go through all of this, but where is the habitat where this bird thrives, and where's the critical habitat? Don't worry about it. We're not going to list it. They did say 2 years later, they said, give us 2 years. We're going to do some more studies. We're going to get back to you on that habitat, and we're going to have that habitat set. So 2 years come and go. They do not designate critical habitat. That was 1992. As our lawyers for the case, I will ask, we've had some movement as of this morning, but February 6, 2018,
Still no critical habitat designated.
so we are protecting this bird. We're protecting the habitat. What habitat is that? I don't know. There has been no designation of critical habitat some 26 years later. But the problem is on our land, almost 2,400 acres, we got a letter from Fish saying that approximately 84.5% of your property would be habitat for warblers. Again, interesting to say, would be, could be, should be. So if you look at, we had real estate appraisals done because, again, we have a fiduciary duty to maximize revenue. It was a drop in over 35% of if we did have warblers versus we did not have them. So we're looking at millions and millions of dollars impacted by this. So in 2015, Texas A&M did a new study on the warbler and said, guess what? From the time of 1990 until now, we have looked and there are 5 times more warbler habitat available than there was in 1990. Not only that, there are 19 times more warblers themselves. This should be, when you go back and read the original language, this is, by all accounts, a success story. It has worked. There's 5 times more habitat. We don't know where that is. but it's there, and there's 20 times the amount of warblers. This is a success story. Fish did not think so. We have filed suit, TPPF is representing us in that suit, to delist the bird. Again, with this same study saying, you have violated the Endangered Species Act. You did not designate any critical habitat. You have failed to do so for more than 2 decades. The warbler has thrived. It has been continued success. So we're pushing through that. It's really more of an outpouring of what this expanded regulatory state under the previous administration has become. It's a battle to say, look at the original language. This is an overall success. You have dropped the value of my property millions and millions of dollars. Let's go ahead and remove that and allow us to go on. We will see what Fish and Wildlife does with that petition, but it's kind of where we currently are, and I think highlights some of the issues that we face today with the ESA.
Well, great, Mark. Thank you for that. And in pulling out in a different perspective, for sure, ground zero of the impact of the Endangered Species Act, I think, has been felt the greatest in the Rocky Mountains and the mountain states, where there's been so much public lands and so much management. And certainly the champion for liberty and property rights in the mountain states, the Rocky Mountains, has always been Mountain States Legal Foundation. So to focus on a different species, in this instance, the Yellowstone grizzly bear, I've invited Cristen to come and talk about how her organization is leading that fight involving that species on, again, what should be a success story that we should be applauding as opposed to a continued ongoing fight against the federal government. Cristen?
Thank you. And thank you for the invitation. It's a delight to be back in God's country here in good state of Texas. As Rob mentioned at the beginning, the Endangered Species Act was signed into law in 1973 under President Nixon. Just 2 short years later, the grizzly bear was listed as a threatened species, and shockingly, no critical habitat was designated. But there were 6 recovery ecosystems that were recognized when Fish and Wildlife got together and started crafting its recovery plan. For perspective, though, the historic range of the grizzly bear is effectively, it spans the entire West and Midwest here in the United States, as well up into Canada. Fish and Wildlife started the current debate back in 2007 by publishing a final rule that designated the greater Yellowstone ecosystem grizzly bear as a distinct population segment, and then simultaneously delisted it in the same rule. Environmental groups, of course, immediately challenged it, and the Ninth Circuit actually agreed with them. I know that's a surprise to all. They vacated the rule, the designation and the delisting, and remanded it for more research, demonstrating why the loss of the white bark pine which is a food source for the grizzly bears, wasn't a threat to the population there in Greater Yellowstone. So Fish and Wildlife in 2013 established a minimum population goal of 500 bears for the Greater Yellowstone ecosystem. In today's estimations, we're running at about 700 grizzly bears in that population segment. In 2016, based on those numbers and the additional research that Fish and Wildlife had done, they again proposed a similar rule to establish the Greater Yellowstone ecosystem grizzly bear, because I couldn't find a longer name for it, as a distinct population segment, and again delisting it. The accompanying conservation strategy addressed that sticky issue that the Ninth Circuit had raised about that pine bark, and they noted that there had been a substantial decline in the white bark pine, but unsurprising to anybody in this room, the grizzly bears had adapted. When there was white bark pine available, they ate it, and when there wasn't, they ate something else. And they're all very healthy 700 bears. The final rule and its associated recovery plan were published in June of last year. And the Fish and Wildlife Service had a bunch of good data points to support the decision that they had made to delist it. Some of that includes the population projections indicate that the greater Yellowstone grizzly bear population has a 1% chance of going extinct in the next 100 years and a 4% chance of going extinct in the next 500 years. The bear has successfully recolonized 92% of its suitable habitat, which nearly doubles the range that it included, that it was in the 1980s. And the peripheral grasslands that it has not started, nesting in it has been historically proven as unsuitable habitat. The area within the distinct population segment boundaries is sufficient to meet all the habitat needs of a recovered grizzly bear population. The greater Yellowstone grizzly has recovered beyond the goals that we set in 2013. And the Yellowstone National Park, Grand Tetons National Park, and the affected national forest have already incorporated the 2016 Conservation Strategy habitat standards into their existing management plans. And if I can just be clear for just a minute, delisting the grizzly doesn't mean that it's entirely deregulated. It just means that the management of the species returns to state hands where it should have been in the first place. For those lands that are not actually owned by the federal government, which by my list you can see is quite a bit in this instance. So for the case update, when the final rule was posted, a variety of environmental groups and several tribes, including the Crow Creek Sioux tribe, immediately filed their 60-day notice of intent to sue in the district court in Montana. The first suit was filed last June. And by the end of August, we had 5 separate suits challenging the delisting under the Endangered Species Act as well as the Administrative Procedures Act. In December, the court decided to consolidate all of those 5 cases into a single case, and of course the federal government, which is the defendant in this instance, moved for a stay, which, as you can expect, was opposed by all 24 plaintiffs. The court's going to hear oral arguments on that motion to stay in March of this year. The states of Wyoming and Idaho and the NRA's Safari Club have already intervened on behalf of the government to support the delisting. But here's part of why this case is interesting beyond the obvious fact that we're actually talking about taking something off the endangered species list. In August of last year, the DC Circuit ruled in a case called Humane Society of the U.S. versus Zinke. In that instance, it was talking about gray wolves that are in 9 of the Great Lakes states, and in that instance they had designated a segment of the population and delisted it at the same time as we have here in Grizzly. The Humane Society was also alleging that the ESA and the APA were both violated in that instance as well. So the DC Circuit back in August vacated the rule, holding that the government failed to reasonably consider 2 significant aspects of the rule. The impact of a partial delisting and the impact of the historical range loss on the listed species. Curiously, back in December, in response to that ruling, Fish and Wildlife published in the Federal Register seeking comment on how that decision is going to impact the rule under consideration here, the rule that is being litigated here, which is uncommon because essentially Fish and Wildlife is seeking a legal opinion through their comments rather than simply asking for factual questions or answers to factual questions about the rule itself. The obvious legal problem with this is that the feds are effectively admitting that the DC Circuit opinion applies to the current litigation instead of trying to dismiss it as non-binding. But to answer their question, the DC Circuit opinion could impact the current litigation in a couple of important ways. The court stated that Fish and Wildlife does have the ability to distinguish a distinct population segment and delist it at the same time. We like this part. It keeps the bureaucratic red tape to a minimum and prohibits unnecessary delays through regulation. That's a good thing. But the court also stated that the Fish and Wildlife Service must consider the effect of distinguishing a distinct population segment and delisting it as it affects the rest of the listed population. The court also stated a species does not have to fulfill its historic range. to be delisted, which again is good news, because trying to make sure that grizzly bears exist in healthy populations all the way across the West and Midwest is not only unrealistic in the world that we live in, but would probably also cause some human habitat issues as well. But the court stated that Fish and Wildlife must consider the effect of the loss of that total historic range on the delisted species. So the question that we are faced with at the moment is, what are the feds going to do? We don't know if they are making these inquiries because they believe the information that they need is already in the rule and they're trying to shore up their existing arguments, or if they believe that they are deficient in their existing rule based on the DC Circuit opinion, and that they need perhaps to seek a voluntary remand to go back to the drawing board on it. So, thank you.
Imagine grizzly bears in your backyard, I think, in downtown Denver. Thank you, Cristen. So we've had the bird, which is this big, the warbler. We've had the grizzly bear, which is much larger. And now we're going to shift our attention and talk about the bone cave harvestman, which is a tiny subterranean arachnid species about as large as the nail on your pinky finger. Exists only in Williamson County, a little bit in Travis County. And part of the interesting aspect of it that Ted will speak to in a minute is looking at the constitutional implications of the Endangered Species Act and how under Article 1, Section 8, the Enumerated Powers Clause of the Constitution sets forth the powers the federal government has, one of which, as you heard Senator DeMint refer to, is the Commerce Clause, which was never meant to give the federal government power over everything. And yet that was the constitutional basis with which Congress enacted the Endangered Species Act in the first place. So as a short introduction to the bone cave harvestman species, we've got another video for you to cue up this segment.
Why, it's a friendly neighborhood scout. Hey, you, Scout. Why the glum face?
Gee whiz, mister, you scared me.
What's the matter then, kid?
Well, Pa says we can't go camping on our land anymore. He says...
That's right, Tommy. Camping is prohibited in these areas.
It's Tammy. And why not, mister?
Well, Tommy, just take a look around you. That there's the bone cave harvestman, a spider-like creature.
But I don't see...
Your land is special, Tommy. See, these little critters are unique to Texas and make their homes on pieces of land like this. If you were to, let's say, kill, move, or even harm one of these harvestmen, you could risk going to prison. Careful now, Tommy. There's a family of harvestmen behind you. Wait, not there. Watch out. Poor Tommy. Now see the mess you got yourself into?
I'm awfully sorry. Get me out of here.
Oh, all right. But just this once. There, that's better. You know why you're here, don't you?
'Cause I squashed a bug.
Now, don't be silly. No, you affected interstate commerce.
What's that?
Well, it's the buying and selling of goods across state lines.
But you said Harvestman only lives in Texas.
Remember, kids, if it's breathing, it must be living. And if it's living, it must be interstate commerce. Don't affect interstate commerce. Sound ridiculous?
It's because it is. See, the federal government is, in fact, trying to make the disturbance of these bone cave harvestmen arachnids a federal crime. That means you could go to jail for messing with one of these guys. What's to say that they won't consider that a federal crime? See, at the Texas Public Policy Foundation, we like a little thing called liberty. And so when someone threatens it, we defend it. Now, does anybody know how we get little Tammy back? Nope. I'm not making that phone call.
So a little tongue-in-cheek look at the Commerce Clause aspect involving this case. And before I turn it over to Ted, I do want to point out and really highlight both of the videos that you saw were made in-house here at the foundation. As part of our advocacy work with the litigation, we want to get this out into the public. And so not just in the print medium, but also in making these videos about our lawsuits and litigation cases to try to engage the public and spread awareness. And I think they're high quality, well done here by our communications department team. So Ted, tell me about the cave spider.
So what we've gone over so far really reflects very well what Rob indicated in the beginning. There's a 1976 Supreme Court case, TVA v. Hill, that basically said that critters are to be protected under the Endangered Species Act, whatever the cost, whatever the human impact. And that was true in 1976, and it's becoming ever more starkly true today, as some of these cases illustrate. We've talked about two cases in which the critters at issue have been have been listed as being protected under the ESA, but yet the most important protection, the designating of their critical habitat, has not happened. And there are other outrages, one of which I want to bring to your attention. It's another TPPF case, and it's the Bone Cave Harvestman. Now, this case started outside of TPPF, a group by the name of Stewards of Liberty, and those folks do exactly what their name sounds like. They filed a petition, an administrative petition, with the Fish and Wildlife Service to delist this Bone Cave Harvestman. And as Rob indicated and as the video pointed out, these are tiny spiders that live only in underground caves in certain very limited areas in the state of Texas. And this petition filed, administrative petition, filed by the Stewards of Liberty, basically asked for those species to be delisted, taken off the ESA list, on the ground that they were thriving in these underground areas. And if you're walking on the surface of the ground, you have no clue that they're there. You can't see them, you can't hear them, you can't smell them. I mean, you literally, like the video shows, have to go way underground to even come in contact with them, and who on earth would want to do that? So at the Center for the American Future, we looked at this petition, and we were very interested when the Fish and Wildlife Service, under the prior administration, denied the delisting petition. And so the Stewards of Liberty sued in federal district court here in Austin to seek a judge to overturn that denial. We looked at the case and we saw something actually very interesting and very different in that case. And it comes down to our system of government under the United States Constitution. Article 1 sets the powers of the United States Congress. And Congress, as everybody learned in civics class, has only certain limited enumerated powers. If it's not set forth in Article 1 of the Constitution, well, then Congress cannot act. So the sole basis for the congressional enactment, the Endangered Species Act, is Article 1, Article 1, Section 8, Clause 2 of the U.S. Constitution. And that's the power to regulate interstate commerce, to regulate commerce among the states, trade among the states. And so we thought, well, okay, so you've got these little spiders that live in certain designated caves in Williamson County, only in the state of Texas. What do they have to do with interstate commerce? Well, the answer is they have nothing to do with interstate commerce at all. And so we took the analysis a little bit further Article 1, Section 8, Clause 18 of the U.S. Constitution says that Congress has the power to make all laws which are necessary and proper for carrying out their enumerated powers, the necessary and proper clause. So we asked ourselves, well, was it necessary and proper for the Fish and Wildlife Service to regulate these little bugs that live only in one state and only in certain limited areas underground in Williamson County from Washington, D.C.? Was it necessary and proper under the power to protect interstate commerce? And the answer that we came up with is no, that can't be necessary and proper, even if ESA regulation has to be done whatever the cost. Whatever the cost cannot include violating the United States Constitution. That can't be included in the U.S. Supreme Court opinion from TVA v. Hill. So we petitioned to intervene in that case based on our reading of the necessary and proper clause in connection with the Commerce Clause. The court approved our intervention petition. And, you know, the necessary and proper clause has a long and complex history in federal jurisdiction, as does the Commerce Clause. I'm not going to get into too much of the weeds right now. Maybe we can discuss that a little bit more during the Q&A session. But I will say that the litigation is pretty far advanced at this point. There have been cross motions for summary judgment filed by all of the parties, and the hearing on that case is scheduled for early March before Judge Yackel right here in Austin Federal District Court. There's another ESA case that I want to just mention very briefly, and that is a case that some of you may be familiar with, but it hasn't been well advertised. How many people here in the audience are familiar with the acronym PETA? People for the Ethical Treatment of Animals, okay? Well, there's another group whose acronym sounds very much like PETA, but that acronym, it's difficult to pronounce. It's PETPO, and it's called People for the Ethical Treatment of Property Owners. little bit of a different swing on it. So there, PETPO filed lawsuit in the federal district court in Utah, arguing very much the same kind of thing, although with a little bit of a different twist, that the Utah prairie dog, which is limited in its residence and life cycle to the state of Utah, cannot be regulated under the ESA consistent with the federal Constitution. Interestingly, a couple of years ago, the district court held in favor of PETPO and said, yes, you cannot apply ESA to solely an intrastate species. Unfortunately, very recently, the 10th Circuit overturned that district court determination. The case was brought up in a writ of certiorari by the PETPO people, which was denied, unfortunately. So under the 10th Circuit standard, you can regulate purely intrastate species, and it's a very, I'll call it kindly an interesting opinion, because basically what they said is all life is interconnected on the planet. It's kind of like the theory of if a butterfly waves its wings in Nebraska, it'll be felt in Beijing. So all life is interconnected, and because the Utah prairie dog is part of all life, it's somehow connected with interstate commerce. That's perhaps an uncharitable characterization, but not an unfair one, I don't think. I see that my time has expired, so I'll save the rest for later.
Well, good. Thank you, Ted. And Now for some questions about the Endangered Species Act and kind of to work into that with what Mark and what Cristen said with their species. You know, the issue about defining critical habitat is a litigated issue. With Ted's comments on the bone cave harvestmen, you know the habitat. There's these very specific caves just in Williamson County. But one interesting note to add on that case, one of our clients is Williamson County. And part of their requirements in complying with the Endangered Species Act for this little cave spider is that they have to go every year and spend tens of thousands of dollars to treat the fire ant beds around these caves so that the fire ants don't get into the caves. So literally, it's requiring us to stop Mother Nature from doing what Mother Nature would naturally do as part of complying with the Endangered Species Act and spending thousands of your tax dollars in getting to that point. Coming back to the issue of critical habitat, a couple of questions that I want to ask before we get into our greater discussion. Mark, Cristen, Ted, I know that you three are aware that the U.S. Supreme Court has decided to take up a case involving the Endangered Species Act and has recently granted cert or review of a case called Weyerhaeuser Company versus the United States Fish and Wildlife Service. And in this case, what's at issue is a species called the dusty gopher frog. They've got great names. But the dusty gopher frog, as a way of introduction, there's only 100 of them. And these 100 dusty gopher frogs exist in Mississippi. And when the U.S. Fish and Wildlife Service was going to designate the dusty gopher frog, they did not have enough acreage in Mississippi for as big a preserve as they wanted. And so what they did is they went into Louisiana and they designated thousands of acres in Louisiana to be critical habitat for the dusty gopher frog. The big problem being that the habitat they designated in Louisiana is inhabitable for the dusty gopher frog. There are no dusty gopher frogs in Louisiana on that acreage, and everyone agrees that if you were to put a dusty gopher frog on that acreage in Louisiana, it would die because it is not habitat or habitable for the species. And yet it has been listed by the Fish and Wildlife Service as critical habitat. So my question to the panel, because the question is to the United States Supreme Court, is whether critical habitat is required to actually be habitable for the species, and where that puts us today when this is a question that has to be answered by the United States Supreme Court. Mark?
I like that case. I hope they take it up, and here's why. People look at me and go, that's terrible. Because if you are able to designate habitat in another state in a inhabitable condition to the actual species, if that is not a Fifth Amendment takings, I don't know what is. We haven't had that many successful challenges of regulatory takings under the ESA. We have acreage right now at the GLO where, aside from the warbler, we are potentially losing millions and millions of dollars, but that's not a regulatory taking. You're just rendering my land worthless. So in one way, that case scares me to death, but in another way, I think the flip side of that is if we can't make a regulatory taking claim out of that, I mean, you've got private landowners in another state where Fish and Wildlife is coming in saying, yes, I'll take your land. It's perfect for a frog. We don't know how we're going to get the frogs over there, but that case scares me to death in one way, but then in another way, I think if we can't prove that, it is. Yeah, we should all just go home at that point.
So Cristen, to get your thoughts here, standing in this room in Austin, Texas, is this dusty gopher frog habitat? And what do you think?
Well, it might be. You don't know. No, As it relates to the grizzly, one of the challenges that we have to the current group of 24 plaintiffs is they're talking about that because we don't have a critical habitat established for the bears. They're talking about the historical range, which is, I mean, draw a line down the middle of the country and move west, and that is their historical range, and that's what they want. A noted number of healthy bears to be located in, and that's just beyond unreasonable. That's not something that we can or frankly should accomplish because as it turns out, people have moved into a lot of those places. And one of the things that we fight a lot at Mountain States Legal Foundation is the creative ways that the government uses regulation to essentially seize ownership or control over even private property. If you look at the wetlands in the western United States, huge swaths of it belong to the federal government wholesale. They own it. They can do whatever they want to with it, with or without regulation. It's theirs. They are the property owner. But I guess the added offense is that they are now using regulations like the ESA in entirely illogical ways to gain access and control over private property, whether it's Petpo or the dusty gopher frog or whatnot. So there you go.
So let me ask, thank you, Chris. Let me ask Ted to push back a little bit. Let me put my environmental activist hat on for a second. Mark and Kristen's earlier remarks were talking about these two cases where the Fish and Wildlife Service have not designated critical habitat. And yet here in this dusty gopher frog case, the service did designate critical habitat. I mean, it's illogical, it's not actually habitable, but they did, draw a line out there and say, here it is. So isn't that what we want? I mean, isn't that the fix that we're complaining of in our warbler case, or why not?
Well, it is and it isn't. In our warbler case, one of the problems, as Mark has mentioned, is that critical habitat has not been designated for decades. And there's just a logical inconsistency. Congress enacted the Endangered Species Act in order to protect species. And the Endangered Species Act, by its terms, says that the best way to protect species is to protect their critical habitats, okay? So if you're gonna list the species as worthy of protection, but not designate critical habitat, there's just a logical disconnect there. So that, well, how serious are you that you want to protect the species if you're not doing that which is most important to protect the species, which is designating critical habitat? And that's one of the issues that we raise in the warbler case. Now, in the Weyerhaeuser case, they did designate critical habitat. And of course, they designated it where the creatures don't live and where they never lived. But there's another issue in the warbler case that strikes me as being even more ridiculous. And that's the issue of whether the circumstances under which federal government action can be reviewed by a court at all. The issue of judicial reviewability. And that's up at the Supreme Court now on petition for cert in the Weyerhaeuser case. And I just want to share with you for a moment or two how ridiculous this issue is as framed. So what the government is arguing is that whenever critical habitat is designated, in those instances where the government chooses to exclude certain areas from critical habitat designation, to exclude certain areas, in those instances, judicial review is available. So they look at 100 acres and they say, well, we're going to exclude the northwest 25 acres from critical habitat. There, the government says, yeah, you can get judicial review. Well, who's going to want to judicial review that? The environmental advocacy groups. So for exclusion decisions by the government, judicial review is okay. The flip side of the coin, though, is that the government is saying that when you include areas as part of critical habitat, there is no judicial review that's allowed. So you go back to our 100-acre example, you can get judicial review for the decision to exclude the 25 acres, but you can't get judicial review to include the 75 acres. And I mean, if you just think about it, exclusion and inclusion are part of one indivisible decision-making process, and that is, what are we going to leave in and what are we going to leave out? And when you decide to leave something in, you necessarily say, well, we're going to leave everything else out. And when you decide to exclude something, you necessarily say everything that's not excluded is going to be left in. It's one indivisible process. And yet, the argument is that exclusion decisions can't be judicially reviewed, whereas inclusion decisions can. I'm sorry, it's the reverse. Yeah, I get confused with this because it's so ridiculous. Excluding decisions can be reviewed, but inclusion decisions cannot. And believe it or not, the appellate court upheld the government's argument on that score, and that's what's going up to the Supreme Court. And that, on the issue of judicial review, to me, is fundamentally actually more important. Because it goes way beyond the Endangered Species Act. It goes to the very heart of our separation of powers. If you're gonna draw this kind of distinction between when judicial review is available and when it's not, then where do you end? So that's my soapbox.
We're all standing on the same soapbox. Cristen, to lead off with the next question, you know, one of the common themes with the three species that we discussed here today is that the most current and recent science demonstrates that the species has recovered and is flourishing. The warbler is 19 times greater than when it was first listed. The grizzly bear threshold was 500, there's 700. The science in regards to the cave spider. You had a recent case come out of DC, the Buffalo Field Campaign versus Zinke case, and this involved evidence needed to list or delist a species, and how it was found in error that the service did not take into consideration the correct information. But from your perspective, Cristen, you know, kind of how do you prove a negative, and would you talk about the difficulty in proving science of recovery in the context when you've got perpetual regulation and the government is usually opposed to taking species off of the list?
Sure. One of the bigger challenges that we've had in delisting is the government scientists themselves, and getting them to either the level of scientific inquiry that we expect of just about everything else in our society, and getting them to basically abide by the common rules of the road that we all agree with in every other scientific endeavor. And to answer your first question, I don't know that you can prove a negative, which is one of the biggest challenges that we have. But you know, the challenge that we and groups like TPPF and Mountain States bring is we do end up having to do a lot of our own scientific inquiry to prove that, yes, there are 700 grizzlies out there, and we have lots of, we call them cubs of the year, which is newborn cubs born in that year. And they're out there, and if you want to, you know, come with us on our four-wheeler, we can go, you know, duck, duck, goose and count them all. But yeah, it is, that is one of the bigger challenges that we always end up having is our scientists say this and your scientists say this, and it has been interesting in this administration because we do find ourselves on the side of the government scientists that we're typically fighting, and we at Mountain States keep looking over our shoulders saying, wait, are we, yeah, nope, we're still on the right side, yep, this is, but we are supporting the government in this, and the challenge that we have is continuing to hold their feet to the fire. It's the reason that we want to intervene in cases like this, so that we have the standing should the government not follow through on this principled decision, to be able to continue fighting the good fight and demonstrating with our scientists, if necessary, that we do have the species in Yellowstone has recovered to the point that we can turn this territory loose and give it back to the states and let them do their good work, making sure that this population does in fact stay recovered and is not, as the 4% might indicate, extinct in 500 years. So.
Well, thank you, Mark. It sounds from some of the earlier comments that the answer back from the service would be the legal argument of the government always wins. But, you know, from your perspective, representing the agency that has so much acreage and in our effort to address species that have recovered, how do you think it should work? And what is your viewpoint on how science can, you know, show that species should be taken off of the endangered species list?
It's kind of a double-edged sword, because we hear about we've got to have the best available science. That's what we're basing all our decisions on, and they fall back to a scientific standpoint. One of the issues I think that highlights this very well is, apart from the warbler, we have had, and there in the warbler, studies have shown they've recovered immensely, and they don't want to see it. They acknowledge, yes, here's this study, now go away because I need the best available scientific data. And you're going, it's right here versus the 25-year-old data you have. One of the instances, even under the new administration, and what we're hoping for that we've seen, we had in 2010, this was at the height of Center for Biological Diversity and Defenders of Wild Earth Guardians had just entered into, I can't remember the number, they had like a listing of 800 species or something. It was this huge sue and settle movement. At that point, they were coming after the Permian Basin, at which the PSF had made hundreds of millions of dollars in oil and gas revenue out there. We worked with them to go into a voluntary conservation plan on the dune sagebrush lizard, and they said, we need the data. And when I say they were scared that this thing was going to get listed, I'm not criticizing anyone, because I would have bet you any amount of money that it would have been listed. Under the Obama administration and what we had moving, this was the biggest skin you could hang on your wall. This was your 12-point buck to say, man, we just shut down Texas oil and gas. I mean, that would have been their dream. So we enter into this map, and it's showing, okay, there could be lizards here, there could be some here. Are we good with this? Fish and Wildlife said, yes, that's fine. We kind of agreed. We were all a part of that. Now we have a new resource out there, frac sand development, that can be used for these oil and gas developers in the largest oil and gas basin in the world out there. And we're going to Fish and Wildlife saying, we've got operators spending hundreds of thousands of dollars to come in and say, okay, we're going to mine this section. Let's look at this section and let's see, are there any of the species on here? Do they exist? Can they exist? And Fish and Wildlife now is going, we need the best scientific data. Well, you've got a hastily drawn map that's now put together in 2010, 11. It's 8, 9 years old. Now we have a better understanding of the species. Here's the information, here's the data, and they say, oh, we don't want to take a look at that. So they always fall back on, we need the data. When the data says this thing should be listed, they're going to hold that up. And when you come in and you say, here is data from yesterday, and here is when it shows very specific species and migratory patterns and feeding patterns, and they go, no, that's not it. And I don't know how you force them. And I think under the new administration, we are making some progress with this, but I think this litigation like this is a way to highlight the issue, to say, here's the problem, here's the best scientific evidence available. Let's take a look at it.
All right, thank you. Ted, your thoughts?
So I think that a lot of the issues come down to what procedure are you using in order to accomplish your delisting objective. In the warbler case, what we have used is a so-called 90-day petition. And in the 90-day petition, basically, we presented evidence to the Fish and Wildlife Service that the warbler not only is recovering, but it's thriving. So in a 90-day petition, the standard is not the best available evidence, but it's a much lesser hill to climb. The standard is whether the 90-day petition supplies substantial scientific and commercial evidence to support a judgment by the Fish and Wildlife Service to enter into a 12-month review to determine whether or not the species should be delisted. So it's what lawyers traditionally call the substantial evidence test. And all that means is, can a reasonable mind reach the conclusion that the species maybe ought to be delisted? And it's not a very high bar. So in our warbler case, the Fish and Wildlife Service said, no reasonable mind could say that the warblers maybe ought to be delisted, which of course is ridiculous. Same thing with regard to the Stewards of Liberty lawsuit with regard to the Bone Cave Harvestman. But then you contrast that with the actual decision in the 12-month review, the 1-year review. There, the issue is best available scientific and commercial evidence. And there, the standard, for those of us on the outside looking into government, there the standard is much tougher and much more stringent. We have to show, on balance, that the best scientific and commercial evidence argues in favor of delisting. But neither the Bone Cave Harvestman case nor the warbler case is at that level. We're at a much lower threshold here, where it's just, we have to show them that maybe it ought to be delisted to continue into the next phase. So a lot of it depends on the standard. And, as lawyers, we don't want to pretend to be scientists or highly skilled technical experts, because we're not. That's why we went to law school. We're not good
Not
with,
even close.
We're not good with science. We're not good with numbers. We're okay with words sometimes when we're lucky. And that's why in a lot of these cases, it is very important to have expert scientific and technical consultants on whom you can rely to really prove your case, either the substantial evidence case or the best available science case.
So last question, and then we'll turn to you and hear your thoughts and your questions for the remainder of the time. But we're going to do a lightning round type format here real quick. So my question to each of you three is, I'm going to make you, Secretary Zinke for this afternoon, or give you the power of Congress. What is the one change in the Endangered Species Act or ESA policy, if you had to pick anything, but you could only pick one thing, what would you choose that would make the best difference in protecting property rights and restoring the balance that I think our discussion here today has shown is out of whack? Ted?
I think just, if I may, I'll change the question to the one I wish you had asked. What are the top two things? For me, number one would be whatever the cost. change the ESA so that the 1976 Supreme Court decision of whatever the cost is obliterated. And number two, include in that, well, actually three. Number two, to include in that a requirement that economic impacts be a substantial decision, not only for critical habitat designation, but also for listing decisions. What are the effects on human well-being, the public good, as it were, as opposed to good for any individual species? And number three, I would change the ESA just to make sure that any government decision is judicially reviewable, for heaven's sakes.
Kristen?
I'm going to go with the enabling clause. Just-
Strike the whole thing?
Yeah. No, conservatives are, we are the original conservationists. We believe that we need our natural habitats. We need the critters that occupy them. And so Ted got long-winded and stole all of my answers. But, at the end of the day, what is needed and what is definitely missing is that reasonable balancing between making sure that we are taking care of this beautiful country that we have been given, and making sure that the people are able to make use of it and prosper inside of it. So.
Good, thank you. Mark?
Okay, this is going to show the difference. Those are very well thought out answers. This is from the cold heart of an oil and gas attorney. The way you cut out, in my opinion, the reason we're having these over and over and over, the way you cut out 90% of the problem is follow the money. The sue and settle provision is absolutely killing us. They're not doing this to protect species. They're doing this because they're lawyers, and God love them, I'm one of them. They can smell the money. There is the largest payout, I have this on here, for attorney's fees was $5.6 million in 2010 as part of a settlement with the Department of Interior under the Endangered Species Act. The reason they're doing this is because they can, and they can make a lot of money off this. If you try to go in and amend the Species Act, you become, you're this cold-blooded killer and you hate grizzly bears or panda bears. They're going to find the cutest thing in the world and stand it up there and say, this is horrible, you horrible person. But are you going to find that same level of resistance if you're protecting plaintiffs' attorneys? Again, being one of them, I can say, look, let's keep what we have in Endangered Species Act, but maybe you don't get the exorbitant attorney's fees. Maybe you don't get attorney's fees at all, and maybe we should cut out this sue and settle where all of the provisions in the ESA are completely short-circuited, and it's all done behind closed doors. I think if you take that out, even living with some of the other provisions that are in there, if you take the monetary driver behind it, I think a lot of it goes away, because Center for Biological Diversity, Wild Earth Guardians, there's a lot of money in that. And so, and again, that's a cold, cynical oil and gas attorney looking at this, but I think there's some truth to that.
I think it's a realistic perspective. So let's go to questions. Megan, down here with Mr. Sparks.
I'd like a question, and of course, I agree with Mark. That would be my second choice. My first choice is you put an arrow in the heart of the law. And my understanding is the law that was put in effect in 1973 was supposed to be a limited number on federal lands only. Why the Sam Hill are we in Texas? We have very little federal land. We're not only in federal land now, we're in state land, private land. That's where we ought to go. And the second item, of course, is what you've already said, sue and settle. That's absolutely crazy. And the third thing is this thing sunset in the 1990s. Why the heck are we still doing stuff? Who allowed this to get to where we're in state and private property and expand it from a few first critters that they were talking about into several thousand now and continuing to do it? It is exactly what you're saying, Mark. It's a group out there that's making money off this dadgum thing, and why are we pecking around on the edges? Let's go fight the main battle and put enough money in to beat the rascals. And I'd like to understand if I'm wrong on the law. You've all looked at the law and find out about that it only had to do with federal land when it first came out. Who expanded that? I don't know that it's been expanded.
Well, it wasn't limited to federal lands originally, but it was more limited than it is now. The problem is that Congress amended it and amended the act several times, and each time made it more and more stringent and grabbing more and more regulatory turf and giving it to the federal bureaucrats. And Congress tends to do that. And it doesn't seem to matter much whether it's a Democrat or a Republican Congress. They all tend to do it. And I think it comes down to, you know, the more power you have, the more power you want. I think it was Lord Acton that says, power corrupts and absolute power corrupts absolutely. And I think that's what we're facing with our federal government.
More, Cristen?
I don't have a lot to add to that. I'm so sorry.
Well, good. Yes, sir.
What are the alternatives to doing what is sue and settles? I understand that the ESA allows for third-party lawsuits, and so just anyone anywhere can find some sort of justifiable nexus to file a suit in defense of some critter. Is that another alternative to doing what is sue and settle, to limiting parties to a case?
I think it certainly could be. In 2015, I believe it was, we had worked, our office with Cornyn had tried to get a bill going to deal with the citizen suit thing, not limiting it so much to say no one can do it, but if there is a citizen suit brought, then there should be, if we're going to go down that path, then you should allow state, counties, local municipalities to intervene in the lawsuit and say, okay, you're coming in and placing federal regulations on my property. How about you let me have a seat at the table at least? So again, I think something along those lines just to make sure that it's not all done in the dark, and then we get a consent decree at the end of the day, and we don't know what just happened, but a lot of money changed hands and a lot of new animals are listed at that point. So I think, I don't have a problem necessarily. The citizen suit is how we're currently involved in this with the warbler to file for a delisting action. So I think it's, again, the attorney's fees and the fact that let's do it in the light of day.
I just wanted to follow up on that. One nice little victory that we got in the warbler case is that actually 5 citizens group, including NRDC, Environmental Defense Fund, and you name them, the alphabet soup of environmental advocacy groups, sought to intervene in our case to help defend the government, the poor government. And Judge Sparks denied their intervention motion on our objection. So, we'll count that as a victory no matter how small it is.
And if I may, I always hesitate to change the rules too much because oftentimes we're the only ones that follow them on our side of the fence, and handicapping us in a way that would, while it would theoretically limit interventions for, for people who have no good reason, they're just getting in for the attorney fees or whatnot. It also has the greater capacity to limit our ability to push back against government overreach through these kinds of actions.
I think that's a great last word there. And so if you'll join me real quick in thanking Mark, Cristen, and Ted for your time today. Thank you all for joining us.